May I please, Your Lordship? Lordship, I beg to mention a criminal petition for withdrawal for Friday, my lord.
May I please, Your Lordship? My lord, I beg to mention item number 27, my lord. With the consent of others side, my lord, the matter may be adjourned for the.
In hearing matters, we're not passing any orders at this stage. Let the matter reach, we'll see.
May I please, Your Lordship? I am praying for listing of a case for orders on Friday, Lordship. As the case is fixed in on next Monday in the learned report below. But some emergency is there, Lordship, on Friday, Lordship.
When it was last listed,
Last date is Lordship 24/7/24.
what order was passed?
Lordship, in to verify whether the service is completed or not, Lordship.
Okay, for orders.
On Friday.
Your Lordship, I'd like to mention item number 5, Your Lordship. As per the instruction of client, we do not want to press this case, Your Lordship. As per the instruction of my client, I do not want to press the case.
Wait for a few minutes. As the mention is over, we'll pass the order. Wait for a few minutes.
May I please, Your Lordship? Lordship, item number 20, Lordship, 20. Lordship, after 2 weeks, Lordship, and today is some person.
Let the hearing matter reach. Yes.
I pay for listing of a criminal revision. It's for hearing, Lordship. Last listed on,
It will not come for hearing straight away. It will come for orders. Then only matter will come for.
yes, Lordship.
On 9th. Yes.
May I please,
Obliged.
Lordship, I beg to mention for listing of a criminal revision petition for admission, Lordship. On any day, Lordship.
11th.
May I plead, Your Lordship, listing of a criminal revision petition, Your Lordship, for motion, Your Lordship. The connected IA for condemnation of delay has been disposed of in June itself, Your Lordship. The matter has not been listed.
For admission, it will come on 11th.
Yes, oblige, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention one criminal petition for listing for motion, Lordship. Lordship, it was last listed on 2019.
11th for admission.
May I please, Your Lordship, I beg to mention for listing of 2 criminal petition on the next week, my lord, any date, my lord. For orders, my lord.
For orders.
My lord.
9th.
May I please, Your Lordship?
I am deeply obliged.
I pray for listing of an IA, file for implement of a necessary party, then inform my Lordship. Any connected criminal petition.
10th.
I moved a criminal petition, my lord, on 26th July, my lord, but not been listed, my lord. Not been uploaded.
What is the number?
547, public
54.
2007, public 2024.
When it was last listed.
Listed, my lord, disposed of, already disposed of, but not uploaded.
Okay. By this court.
Yes, my lord.
Which date?
26th July,
26.
published.
Lordship, may I? I beg to mention item number 6, Lordship, of today's daily list. The arguing counsel SD Das is not well, Lordship. The matter may be posted for hearing after 1 week if possible, Lordship.
Item 6.
Item number 6, Lordship.
Let the matter reach because this is an admission stage.
Lordship.
We'll look into it.
May I
Yes.
please, Your Lordship? I beg to mention item number 26. Priority may kindly be given to this item, Your Honor, that is, Your Lordship. It got listed several
Mr.
times.
Kalsi, have you informed other side? We can upgrade, no issues. Last occasion also, remember you were
They
there.
are not going to pick up the phone because they are enjoying the stay. That is the issue regarding this.
You are for the respondent, right?
And for the respondent wife.
Kindly inform Mr. Kalita, do you have his communication number? Do you have his number?
I have his number. I will try.
You give it a try, let us know. We'll upgrade it.
Oblige.
Sharma. Inform Koito. Yes.
My pleasure, Lordship. Lordship, I have to mention for listing on criminal petition, Lordship. It was last listed on 28th August, Lordship. Due to the peculiar of time, it was not this, my lord. Lower court date is 10th September, my lord. Can it be on or before 10th?
9th.
9th.
Make a mention in the morning. On 9th, when it will be listed, make a mention in the morning.
No, my lord. For upgrades morning.
Yes.
My lord. Obliged, my lord.
If someone is here. Ako matake, pispole bogi.
Hi.
You are Mr.
Yes, sir, Your Lordship.
Pardon, Mr. Esroy, and counsel appearing for the petitioner. And Mr. K. Boysel and the additional prosecutor, some projects number 1. Responding like opposite party number. Also heard MS R. Chaudhary, land counsel for the opposite party number 2. Agree by the judgment and order it is 06/12/2022. Passed by learned Session Judge Karimganj. In criminal division number 30, judgment itself. Judgment notice 06/12/2022, passed by learned Session Judge Karimganj in criminal division number 38/2021. Upholding the ex parte order to the 28/11/2019, directing to pay monthly maintenance of rupees 3,000 to the respondent number opposite party number 2 and rupees 2,000 each to her children. The petitioner filed this criminal petition praying amongst others for quashing and set aside the said judgment dated 28/11/2019. Password. Not. I think that's not it. During the deliberation of the matter on instruction of the petition, Mr. S. Learned counsel submitted that the petitioner is not pressing this criminal petition. According to criminal petition. That's been not pressed. Registry shall return the record of miss case number 617. Within bracket TV. Oblique 2018. To the Court of Learned District Judge Karimganj. Along with copy of his file.
Much obliged.
That was
I'm highly obliged.
false by order dated. That was earlier court. By order dated 24/07/2024. Welcome correction number.
Much obliged.
I want to discuss.
You are Miss Colita?
Yes.
Or MSP Colita, learned counsel for the petitioner. And MS and Mr. Stewart. Additional petitioners for the opposite party number 1. The petitioner filed this criminal petition. Petitioners filed this criminal petition, praying amongst others for quashing and oblique court will set aside the order dated 14/09/2022. Passed by learned judicial magistrate first class Kolakata in DB case number 80/2022 filed by the opposite party number 2, as well as the proceedings of the subsequent proceedings of the same DB case number such and such. On instruction of the petitioners, Ms. Colita, learned counsel, is for withdrawal of this criminal. To which the counsel for the respondents have no, opposite parties have no objection. They are allowed, petitions then dismissed on withdrawal.
Obliged.
May please, your lordship. Lordship, in this item number 2 has been filed by me and item number 3 was filed by the respondents, lordship. Item number 2 is regarding quashing of a CR case, lordship, of NI case, lordship. In this case, what happened, lordship, the petitioner purchased a traveler vehicle, lordship, on finance, and at the time of purchase, he deposited some post-dated checks, lordship. And thereafter, after some months or years, lordship, flying the vehicle, he surrendered the vehicle before the branch office, lordship. Surrender letter also I have annexed, lordship. And thereafter, they have issued a notice to the petitioner.
Okay. Where is that notice?
Lordship. Surrender letter is page 16, annexure 2, lordship.
Page 62.
16. Annexure 2 is the surrender letter, Lordship.
Okay.
Annexure 3, page 17 is the letter issued to the petitioner, Lordship.
Oh.
It says, Lordship, the second paragraph, despite several opportunities to you, we find from our records that your account is still in arrears wherein you have not taken any effort to repay the outstanding till date. We give below the amount due from as on 12/5/2019. Amount was shown as 84,861, additional finance charges 11,000. So in total, 96,566. Thereafter, another notice was issued from High Court, page 18, Annexure 4, Lordship. Paragraph 2, they have mentioned that you have availed the loan but have failed and neglected to repay the same in time as per the terms and conditions agreed despite repeated reminders, verbal as well as in writing by my client. Thus, you have committed default in making the payment of your due amount as per the terms of the agreement. Some checks issued by you towards payment of installments have been returned unpaid, that it appears that you have approached my client with the sole purpose of cheating my client and thereby putting my clients into wrongful loss. In paragraph 4, they have mentioned in the above circumstances, now your loan account has been classified as non-performing assets and accordingly you are hereby called upon to clear total dues of rupees 96,566, outstanding EMIs along with the delayed payment charge, check bouncing charge, etc., and pay to my client by cash or by pay order, Lordship. So this letter was issued on 13/5/2019. Accordingly, I have filed my reply, Annexure 5, page 19. In reply, paragraph 3, Your Lordship, that due to my client's some personal difficulties, he was unable to ply the said vehicle, and on 25/10/2018, my client intimated the matter to Ankur Chakraborty, manager, Cholamandalam Investment and Finance Company Limited, Dibrugarh branch, and he suggested my client to surrender the aforesaid vehicle at your office at Sibsagar branch, and as per his suggestions, my client have surrendered the aforesaid vehicle along with relevant documents at your office at Sibsagar. The aforesaid vehicle along with documents have been received and acknowledged by one Sri Anuj Kumar Gogoi of Cholamandalam Investment and Finance Company Limited, Sibsagar. That my client, being a reputed person, cleared all his dues till the date of delivery of the aforesaid vehicle to your authority. So the question of defaulter does not arise at all. Moreover, you have no right to classify the aforesaid loan as non-performing asset. That as my client cleared all his dues, so he is not at all liable to pay any amount to you. That you and your office staffs are trying to cheat my client and harassing him only to grab money from him. That at the time of availing the aforesaid loan facility, my client delivered you few checks as per your request, which is not yet used by your authority, which is required by my client as there is no need of the check by you. So in my reply, I have informed them, you please return back my all the checks. But in spite of that, Lordship, they have filed a complaint, that is Annexure 6, page 22, Lordship, under NI Act, Lordship. With the same facts and Lordship pleadings in the notice as they have earlier served. Page 34, your Lordship will find the check which they have exhibited as Exhibit 2, Lordship. Now it has become 6,08,842, Lordship. and check dated 26/9/2019. As per Annexure 3, Lordship, on 12/5/2019, they are saying that total outstanding is 96,566. And within 4 months, Lordship, it has become 6,842,000, Lordship.
Okay,
So I am praying quashing of this NI Act, Lordship, which the court has already taken cognizance, Annexure 7, page 37, Lordship. On 24/2/2020, Lordship, summon was issued to us. And page 38, Lordship, page 3, Lordship, the case was fixed for appearance. Thereafter, we appeared, and while issuing notice in criminal petition, in this criminal petition, the proceeding was stayed, Lordship. Thereafter, it has been stayed, Lordship, the land trial court proceeding. My humble prayer before your Lordship that if I issued the check for post-dated checks for repayment of the amount, Lordship, and when I have already surrendered the vehicle, they ought to have sold out the vehicle and to take the money from that amount, Lordship, which they received from selling the vehicle, Lordship. Instead of that, Lordship, when they are utilizing my checks, which were submitted at the time of purchase of the vehicles, Lordship, and proceeded for NI Act proceeding, Lordship. In this case, I want to rely on some judgments, Lordship.
okay. Yes, you're relying on some judgments. So the
Lordship, that is Sriram Transport Finance Company Limited versus Akila Banu. One, and another one is ING Vyasa Bank versus Hanumant B. Ramdar. And the third one is, Lordship, Indus Airways Private Limited. It will mean. Sriram and Lordship, the ING Vyasa Bank relied on the Supreme Court judgment, Lordship. First, I will take Sriram Transport Finance Company Limited, Lordship. Paragraph 2, Lordship, facts succinctly stated the complainant Sriram Transport Finance Company Limited filed a private complaint through its general power of attorney holder against the accused alleging the offense punishable under section 138 of NI Act. The allegation was the accused, being a customer of the company, availed loan from the company to purchase Tata tipper vehicle for a total hire purchase value of rupees 2,95,000 by executing a hire purchase agreement with related documents in favor of the company. She defaulted and became due to the company for a sum of rupees 60,000 despite several demands. She did not repay the amount. Finally, she paid one account pay check bearing number so-and-so dated 2007, drawn on Bank of India, Hospet branch for rupees 60,000 when the check was presented for encashment. It was returned with an endorsement funds insufficient. The complainant informed the said fact to the accused by way of demand notice and called upon her to repay the amount within 15 days from the date of receipt of the notice. The notice is served through certificate of posting. She refused the notice sent through RPAD. She neither did reply nor did comply the demand. She has issued check knowing that there is insufficient funds in her account, thereby committed offense under section 138 NI Act. So here in this case, Lordship, paragraph 30, your Lordship, and 17, Lordship, paragraph, page 6, Lordship. it was held that the Supreme Court in a case reported in Indus Airways Private Limited and others versus Magnum Aviation Private Limited and another considered the conflicting views taken by the High Courts of Delhi and High Court of Andhra Pradesh, Madras High Court, Gujarat High Court, Kerala High Court, and set the controversy at rest by holding that the post-dated checks issued by the purchaser as an advance payment in respect of the purchase orders cannot be considered towards discharge of legally enforceable debt or other liability, and the consequently dishonor of such check does not amount to offense under Section 138 of the NI Act. In the light of the above, it needs to be asserted that the case of the appellant fails for another reason also, that is not making out a case for an offense punishable under Section 138 of NI Act, and the impugned judgment does not call for interference. Next one, ING Vyasa Bank Lordship. Paragraph 6, the question was put, Lordship, the whether the complainant made out a case that the check in question was issued towards legally enforceable recoverable debt, Lordship. Paragraph 8, it held that without resorting to any legal proceedings, if the bank was able to sell the vehicle within short period of sanction of the loan, in all probability the vehicle must have been hypothecated to the bank, but said fact is not disclosed by either of the parties, neither in the demand notice nor in the complaint, such averment is made. It is the case of the complainant that the check in question was issued admitting the liability of rupees 24,635. It was nowhere stated on what date the loan of rupees 9,90,000 was disbursed to the accused and what date he admitted his liability of rupees 24,635 towards the said loan availed by him. The pleadings in the complaint and the cross-examination evidence of PW1 makes out a case that the check issued by the accused at the time of sanctioning of loan towards the repayment by way of installment is utilized to lodge the present complaint. To make out an offense under Section 138 of the Act, the complainant is required to establish the case that the check was issued towards whole or part of legal debt or liability. In the judgment of Indus Airways Private Limited and others versus Magnum Aviation Private Limited and another, the view taken by the apex court is that a post-dated check issued as advance payment in respect of purchase orders, when on presentation dishonored, does not amount to an offense under Section 138 of the Act. The post-dated check obtained at the time of loan transaction towards future repayment by way of installments does not fall within the ambit of towards discharge in whole or in part or any debt or any other liability. Is the view taken by
Ms.
the...
Chaudhary.
Yes, Lordship.
Yes,
And moreover, Lordship, they have already initiated arbitration proceeding and award was already passed, Lordship.
it was stated so.
And no, Lordship, the arbitration proceeding, I have not mentioned, not annexed any document, Lordship, but it was subsequently passed as I have filed one
Have you
FIR.
annexed the agreement
No, Lordship.
between?
Lord, the case, my lord, is entirely based on false statements. I'll just take you to Paylord, my lord. This is a case of 130, my lord, under the Negotiation Instrument Act, my lord. I'll just take you to 139 of the Act, my lord. This is a case of reverse burden, my lord. In these cases, initially 138 cases, my lord, the burden is upon the accused to prove that there was no existing debt or liability. So there is a legal presumption that the check was issued in respect of a legally enforceable debt. The 139 presumption in favor of the holder, it shall be presumed unless the contrary is proved. Lordship will kindly take note, unless the contrary is proved that the holder of a check received the check of the nature referred to in subsection, in section 138 for the discharge in whole or part or of any debt or other liability. Now, Lordship, I will take you to paragraph, sorry, section 140 below. Defense which may not be allowed in any prosecution under section 138. It shall not be a defense in a prosecution for an offense under section 138 that the drawer had no reasons to believe that he issued the check, that the check may be dishonored or presentation for the reasons stated in that section. Now, Lordship, here is a case where we say, my lord, that an amount is due. Now, Lordship, my learned friend has relied. I'll place the facts from my case, my lord, in item number 3, my lord. But I'll just take you to paragraph, my lord, page 17 of the of item 2, my lord. The notice.
Page number,
Page 17, my lord.
your petition.
No, my lord. The item 2, my lord.
Page 17.
17. It is the notice, my lord. Lordship will see the date is 12/5/2019. There are two aspects, my lord. I'll just read you the second paragraph. Despite several opportunities, you find that from a record that your account is still areas where you have not taken any effort to repay the outstanding till date. You know, this outstanding means the defaulted installments. That was below, we give below the amount as on 12/5/2019. Lordship will kindly note of the date. This is 12/5/2019, my lord. The outstanding amount. That is the defaulted EMIs, my lord. Now, my lord, my learned friend has also relied of the, my lord, reply, which your lordship files at page 19. I'll just take you to, my lord, page 20, my lord. I refer with these documents already in my case also, my lord, that I'll refer, but at the same time, I'll just read out the third line. As per his suggestions, my client have surrendered the aforesaid vehicle along with the relevant documents at your office at Shivsagar. The aforesaid vehicle, along with documents, have been received and acknowledged by Sri Vanuj Kumar Gogoi, so and so, so and so. Your authority have delivered the said vehicle, paragraph 8, my lord. But my client have come to know that after the surrender and delivery of the vehicle, lordship will kindly note this word, my lord, delivery of the possession, my lord. That my client have come to know that after the surrender and delivery of possession of the aforesaid vehicle to you, your authority have delivered the said vehicle to a third person without the knowledge of my client and receiving the EMIs from him, third person, of the said vehicle in my client's name, which is in gross violation of the terms and conditions of the loan agreement, and thus you have cheated my client. Now, the allegation is that, my lord, we transferred the vehicle to some other third person, my lord. Now, which he has come to know. Now, lordship, there are two aspects, my lord. Because, my lord, we sanctioned a loan, my lord. The vehicle was never surrendered, my lord. I'll place it from the documents itself, my lord. The vehicle was never surrendered to us. Now, so far, my lord, the judgment, my lord, I'll just, my learned friend has relied on the judges, Indus Airways Private Limited, my lord. This was a case, my lord, where the deal never took place. I'll just, my lord, before lordship goes to my case, my lord, I'll just place one judgment. This was Indus Airways case was, my lord. This was the case, my lord, where certain things were ordered, but prior to the disbursal, my lord, the deal was cancelled. The party pays the check, my lord. The Supreme Court came to the conclusion, my lord, that since there was no existing liability because the goods were never paid, never disbursed. So this case is quite different, my lord. I'll just relay, my lord, this 2016-10 SEC, my lord. Simply, I'll just take you to not.
But one thing there, in the case of
This was of my learned finance referred to 2014-12 SEC page 539, my lord.
Indus Airways,
Indus Airways case.
if you see
Well, this has been distinguished, my lord. I'll just take you to my lord 2016.
just a minute. In that case also, the Indus Airways prepared an application after the cognizance was taken, which was accordingly allowed,
Not sure.
which was again by the Delhi High Court, it was set aside against this appeal.
Not sure.
So the appellant initially, after taking cognizance of the matter,
Not sure.
filed a revision under section 397 before the session judge, which was allowed. In the present case also, in the item number 2,
Not sure.
the petitioner has filed his criminal petition after the cognizance has been taken. That's how we have seen. Anyway,
Yes, my lord.
now you are saying that this particular matter has been differentiated, right?
Like that, my lord. Right. I'll just take you to my lord. Paragraph 11, my lord. Last part, my lord. It starts with, my lord, in applying the judgment of Indus Airways.
Hmm.
Paragraph 8, my lord, this was referred by the appellant itself, my lord.
Hmm.
Paragraph 11, reference may be now be done to the decision of the court in Indus Airways by so and so, on which strong reliance has been placed by the learned counsel for the appellant. Now, Lordship will come to paragraph 11, last 3 lines, my lord. 4 lines. In applying the judgment in Indian Airways, one cannot lose sight of the difference between a transaction of purchase order, which is cancelled, and that of a loan transaction where loan has actually been advanced and its repayment is due on the date of the check. This there lies the distinction, my lord. Now, paragraph 12, the crucial question to determine the applicability of section 138 of the Act is whether the Act check represents discharge of an existing enforceable debt or liability, or whether it represents advance payment without there being any subsisting debt or liability. While approving the views of the different high courts noted earlier, this is the underlying principle as can be discerned from the discussions of the said cases in the judgment of this court. Now, lastly, if your lordship said, paragraph 18, my lord. Paragraph 16, my lord. I'll just read you from paragraph 16, my lord. As is clear from the above observation of this court, it is well settled that while dealing with a quashing petition, this court has ordinarily to proceed on the basis of the advertisements in the complaint. The defense of the accused cannot be considered at this stage. The court, considering the prayer for quashing, does not adjudicate upon a disputed questions of fact. In Rangappa versus so-and-so held that once the issuance of a check and signature thereon are admitted, presumption of a legally enforceable debt in favor of the holder of the check arises. It is for the accused to rebut the said presumption, though the accused need not adduce his own evidence and can rely upon the materials submitted by the complainant. However, mere statement of the accused may not be sufficient to rebut the said presumption. A post-dated check is a well-recognized mode of payment. Thus, the question has to be answered in favor of the respondent and against the appellant. Dishonor of the check in the present case being on discharge of an existing liability is covered under section 138 of the Act as rightly held by the High Court. Accordingly, we do not find any merit in this appeal and shall be and the same is dismissed. Since we have only gone into the question whether on admitted facts the case of quashing has not been made out, the appellant will be at liberty to contest the matter in trial in accordance with law. So the earlier case goes, my lord. Here it was a case of loan. Now I'll just take you to my case. Look, in fact, there are judgments even when the check and the signatures are immediate, my lord. The entire presumption that the case is for it is Milord, in the, I'll just, Milord, refer to later, Milord. Even in the Bir Singh's case, Milord, even a blank check leave voluntarily signed and handed over by the accused, which is towards some payment, would attract presumption under section 139. So those things are there, I'll place later, Milord. I'll just take you to my case, Milord, item 3, Milord. Like, what had actually happened, Milord, what the statements which have been made in this case, Milord, are all false. Now, Lordship, I'll just take you to page 78 of item 3, Milord. The entire agreement has been, Milord, annexed there. But the events of default is at page 64. I'll skip, Milord, and in fact, I'll just take you to page 78. FF, Milord. Now, not sale. This is for the, Milord, loanee. Not sale, transfer, create, charge, assign, mortgage, pledge, hypothecate, let on hire, or surrender, or or howsoever, part with the possession of the asset, or deal with the vehicle or any part thereof with the express written, without the I'll read it again. Not sell, transfer, create, charge, assign, mortgage, place, hypothecate, let on hire or surrender or whatsoever, part with the possession of the asset or deal with the vehicle or any part thereof without the express written permission of the company previously obtained, except to the extent herein mentioned. Now, Lordship, we have, Milord, enclosed the statement of accounts at page 104. This is, Milord, statement dated 8/11/2023. Net receivable is 12 lakhs 29,103. On the right side, Milord. Lordship has seen.
Okay.
Now, Lordship will kindly, so what had happened, Milord? Lordship will kindly come to page, in fact, Milord, we given a type copy at 154, but I'll take you to 159, Milord. That is the original agreement. The conduct of the petitioner in item number 1, item number 2, Milord. This is an agreement. These are all suppressed before this court, Milord. This is an agreement executed on 3rd of August 2018. This is the first party, Milord. This is the petitioner in item number 2. Now, Lordship will kindly come to page 160 with one Kiran Gogoi. I'll just keep, Milord. I'll just take you to the second paragraph, where the first party is the registered owner of a horse traveler, color white, so and so, being purchased by him by obtaining a loan from Cholamandalam Investment Company with effect on 28/1/2017. Next page, Milord. Whereas the first party on 27/10/2017 entered into a deed of sale in respect of the aforesaid vehicle at a consideration of 2,60,000, so and so, with one Noyanmoni Aradhana, son of Sri so-and-so, resident so-and-so, along with several terms and conditions, and the same was duly notarized before the notary public, Dibrugarh. So, 27/10/2007, he sold off the vehicle. Whereas, as per the convenience of the said agreement, Sri Noyanmoni Aradhana undertakes the liability to pay the remaining installments amounting to rupees 28,287 so-and-so per month on behalf of the first party to Cholamandalam so-and-so till the liquidation of the loan amount. Now, Lordship again see, whereas Sri Noyanmoni Aradhana, without the consent and knowledge and without obtaining any written permission of the first party on 3/3/2018, entered into a deed of sale in respect of the aforesaid vehicle with the second party and handed over the said vehicle to the second party at a sale consideration of 3,20,000 so-and-so. And the said deed of sale was duly notarized before the notary public Shivsagar. Now, here Miller is a Kiran, again Miller, Noyanmoni Miller, he sold it to Kiran Gogoi Miller, who is the Miller, second party in the agreement. Whereas the second party also without the consent and knowledge of the and without obtaining any written permission of the first party on 17/5/2018 entered into a deed of sale with Hirokjyoti Niyog, son of so-and-so, and handed over the said vehicle to the so-and-so at a consideration of so-and-so. I'll just skip that paragraph. Lordship, page 162, second paragraph. Whereas the first party, after knowing the entire facts from Cholamandalam Investment and Finance Company Limited, that 2 installments was due against the said vehicle and the said vehicle was in the possession of the second party. The first party on 25/7/2018 reposes the said vehicle from from Amalapati Dibrugarh and the same is in his possession. So, my lord, there is an admission of default. He says, my lord, he has been paying the installments regularly. Now, next paragraph, whereas the second party, thereafter approached the first party and requested him to deliver the said vehicle with a condition that today the second party will pay the installments amount of rupees 28,287 to the first party in cash, which the first party has paid on behalf of the second party during the month of April, which is the second party. I'll skip that part, my lord. Now, Lordship will page 163, second paragraph. And further, whereas it is agreed between the first party and the second party that the balance consideration will be paid by the second party purchaser by his own initiative on or before 20th of every month to the Cholamandalam so-and-so in 29 equal monthly installments of 28,000 so-and-so. Now, clause 1, my lord, page 163, down below, my lord, that the first party owner today has delivered the possession of the forced traveler color so-and-so, registration number so-and-so, and the balance so-and-so. So, this is, my lord, delivered to the second party. K. Gogoi, my lord. Paragraph 2 says the same thing, that the first party has delivered the portion. So, my lord, Lordship will see, during the substances of the agreement,
Mr. Day,
Lordship,
this agreement
Lordship,
was of 3rd of August.
2018.
What? 50.
Yes, my lord.
But this vehicle was again placed before the petitioner on 25th of October 2018. Was surrendered on 25th of October 2000.
No, I'm coming to that, my lord. All the documents are there, my lord. I'm coming to that. Now, Lordship will see the surrender letter, my lord, which is at page 167. Type copy is at my lord 166, but I'll just rely which my learned friend has also annexed, my lord. This is the same letter. The Lordship will kindly see the contents. With reference to the traveler vehicle loan taken from your company against the above loan agreement, I would like to inform you that I am unable to pay my monthly installments and hence I am voluntarily surrendering the vehicle bearing registration number so-and-so to your branch officer. You are empowered to sell the vehicle and adjust the sale proceeds against my dues. Now, where is the my lord? There was no physical surrender. What had happened, my lord? Gogoi was not paying the installments. I'll come to that, my lord. And he approached us. This surrender letter was issued to him without surrendering the vehicle. My lord, the records will speak for itself, my lord. The vehicle was never surrendered to us. I'll just come to my lord. He has admitted in his FIR itself. One after another, my lord. He says that I am voluntarily surrendering, my lord, without physically surrendering the vehicle. The Lordship will kindly see next page. Lordship, next page, Lordship, page 160 and 169 is the same, my lord. 169 is the receipt. It is same thing, my lord. Lordship will see on 30/11/2018, one installment was paid by K. Gogoi. my lord, if he had surrendered the vehicle on 25/10, my lord, why 30/11/2018 an amount of 28,000 was paid? Lordship will see his name, Dawar Hussain Ahmed. Amount is 28,000. Payment date is 30/11/2018. My lord, if he had surrendered the vehicle, what is the purpose of making this payment, my lord? Firstly, now Lordship will kindly come to page 170, my lord.
Yes.
This is an application by the second party of the agreement, my lord. Application for, this is also 30/11/2018. Application for reassignment of loan account into my name. With due respect, I beg to inform you that I have purchased one traveler vehicle bearing registration number so-and-so on so-and-so from the original owner, namely Mohammed so-and-so, by an agreement. Now I am earning my livelihood plying the vehicle. I am paying the installments of the loan I agreed to pay in future. In that respect, I have been authorized by the above mentioned original owner of the vehicle. Moreover, I have also talked with your office and enclosed all documents and then above mentioned original owner agreed. Hence, I applied for reassignment of the loan into my name and accordingly prayed for to take appropriate action urgently. So, my lord,
In that case, if it
Lordship.
is a case that the second purchaser,
Lordship,
Kiran Gogoi, has submitted this application before you
Lordship,
on 30/11/2018,
Lordship.
the question of giving that check by the petitioner in the year 2019 doesn't arise.
No, it will arise, my lord. It will arise, my lord. I'll place, my lord. No,
Here
my lord.
it is an
Lordship.
admission by this particular Kiran Gogoi.
No, my lord, even otherwise, even if it is a security check, my lord, there are decisions to that effect, my lord. Even a security check, my lord, if the amount is due, my lord, I can collect. There is no bar as such. Then I'll come to, my lord. I'll satisfy on that point, my lord. Now, lordship will see the page 170 is the notice, my lord, which my learned friend has already referred. The legal notice are all annexed, my lord. Now, lordship will kindly come to page 177, annex 10. Now, the lordship will, from the document itself, lordship has come to a conclusion that the vehicle was never surrendered. The physical surrender was not there. The vehicle was with the second party, that is Kiran Gogoi. So, my lord, the question of her case is there, my lord, I have surrendered the vehicle, so I am not liable to pay. That is their case.
Anyway, proceed.
Now, lordship, this is the affair. What he does, my lord, I'll just take you to the original at page 183, my lord. I'll just take you to, my lord, second paragraph. The first paragraph is basically definition. I have been paying the monthly EMIs in respect of the aforesaid vehicle regularly without fail. But due to some personal difficulties, I was unable to ply the said vehicle smoothly. And on 3/8/2018, one Sri Kiran Gogoi, son of so-and-so, resident so-and-so, came to Dibrugarh and approached and persuaded me to deliver the possession of the aforesaid vehicle to him with the condition that he will ply the said vehicle and pay the EMI of rupees 28,287. Lordship, this FIR is dated 15/5/2019, my lord. In my loan account on 28th day of every month to Cholamandalam investment in so-and-so on my behalf, but he failed to pay 3 monthly consecutive installments in spite of my repeated requests and demands. Hence, on 25/10/2018, I went to Sibsagar to take back my aforesaid vehicle from Sri Kiran Gogoi. But he refused to hand over my vehicle and assured me that he will pay the installments due within a short time. Now, lordship will see, on 25/10/2018, the vehicle was in possession of Kiran Gogoi. It is the same date on which he claims to have surrendered the vehicle with the financer. Am I clear, my lord?
Okay.
184, my lord. Thereafter, on 25/10/2018, I intimated the matter to Sri Ankur Chakraborty, manager so-and-so, who suggests me to surrender my aforesaid vehicle at Sibsagar branch. As per his suggestion, I surrendered my aforesaid vehicle at Sibsagar branch, and the said vehicle was duly acknowledged. Now, lordship will see the said vehicle was duly acknowledged. The vehicle is with some other person. I acknowledge the vehicle, without bringing the vehicle. So-and-so, once you want to go and financial so-and-so. Now, but surprisingly, sir, on 8/5/2019 at about 1:30 p.m., Sri Ankur Chakraborty, so-and-so, who is a resident of so-and-so, and with 4 other persons came to my house situated at Anandanagar and asked me and my father Mohibul Ahmed, who is a guarantor, to immediately pay 3 month installments due at a time. It is pertinent to mention that since I have surrendered the aforesaid vehicle on 25/10/2018 to Cholamandalam Investment and Financial Company Limited, Sipsagon, so the question of paying installment at this stage does not arise at all. And because there are, as per the surrender letter 25/10/2018, to sell my aforesaid vehicle and adjust the sale proceed against the law, against my dues. He again relies on that surrender letter. But after going through my loan statement, I was very much astonished to see the Cholamandalam Investment and Finance Company, instead of selling my aforesaid vehicle, which is in their possession, is still recovering on my behalf the installments from some unknown person since October 2018 to February 2019. Lordship will see which is in their possession. Further, from some reliable sources, I came to know that Ankur Chakraborty, in collision with Sri Pulo Kolita of Sipsagar, for some wrongful gain, had dishonestly and fraudulently concealed my aforesaid vehicle and demanded and claimed installments to which I am not entitled. Now, from the aforesaid conduct of the Cholamandalam Investment Financial Company, I had every apprehension in my mind that the bank authority is playing a foul game in order to harass and to make easy gain by blackmailing me in all possible aspects. Now, Lordship will see, now, Milord, a financier company particularly, Milord, what mens rea will it have, Milord? The case registered, Milord. Now, Lordship will see on the very next date, Lordship Milord, at page, annexure 11 at page 186. The original is, Milord, at page 187. He challenges my conduct, Milord. Look at his conduct, Milord. This is of 13/5/2019. I'm just reading from the original, Milord. In inviting the subject under reference, I, Dalwar Hussain Ahmed, enclosing here with a demand draft rupees so-and-so on 31/5/2019 of Union so-and-so, in lieu of the final settlement payment against the loan of the vehicle bearing registration number AS20 so-and-so. I would like to request you to kindly acknowledge the receipt of the same and provide me required NOC and other relevant documents as per procedure. Kindly do the needful at the earliest. Now, Lordship, along with it, he gave us a check of 5,70,000, which demand draft, Milord, at page 12. Sorry, page 188, annexure 12. Well, thereafter he withdraws it. He comes to the bank and said, Milord, please do not place the demand draft. He said, Milord, he will be producing a check, Milord. And in fact, Milord, thereafter, these are the bail applications, bail petitions, Milord. And Milord, thereafter, Milord, page 198. I'll just show, Milord. He says that there is no liability. On the face of it, everything will be clear, Milord. This was a direction under section 91 CRPC, Milord, to produce the documents to the branch manager. Agreement set in respect of Dalwar Hussain Ahmed against traveler number so-and-so, loan agreement statement, any other documents related to the agreement set in respect of Dalwar so-and-so. So, Milord, thereafter, we produce all the documents which your Lordship will find at page 200. The copy of the loan application, there are seven things, Milord, which were provided. And in fact, Milord, there is no seizure to that effect. That is why I had to come, Milord. And Milord, 201 is the notice which my learned friend had already referred. That is 10/6/2019, the advocate, Milord, against which we had applied, replied, Milord, at page 204. I'll just, Milord, Milord, thereafter, Milord, the charge sheet was submitted, which your Lordship will find at 214, Milord, annexure 16. Lordship will kindly come to page 220. Milord, why we were required to come, Milord. Accordingly, page 220, Lordship, last 4 lines. The mechanical submission, the charge sheet was submitted, my lord. Now, my lord, this is a page 220 is the charge sheet, my lord. The translated copy, my lord. I'll just take you to last 4 lines, my lord. Accordingly, as per advice of Sri Ankur Chakraborty, the informant handed over the vehicle to the now handed over the vehicle. This is also not from the record, my lord. Because the seizure list itself will reveal, my lord, the vehicle was recovered from some other person.
Recovered from whom?
Lordship, I'll come, my lord, at the all at annex, my lord. It's a sequence, my lord. Accordingly, as per advice of so and so, the informant handed over the vehicle to the company having his branch officer so and so. An acknowledged receipt of the same. Now, question of handed over does not arise, my lord. Surrender and handed over, there is a, my lord, first distinction. Now, Lordship, I'll just 221, my lord, second paragraph. During the investigation of the case, earlier investigation had interrogated the informant, visited the place of occurrence, prepared sketch map, and interrogated the witnesses of the place of occurrence. Again, visited the branch office of Cholamandalam Minister so and so and recorded statement of the witnesses and seized some documents. During the investigation, Soumitra Borbora, a branch manager of so and so, and accused named FIR Junu Gogoi were interrogated and finding no evidence of the involvement with the case, they were allowed to go from the police station and with the advice to cooperate with the investigation. Later on, the accused so and so after obtaining interim bail from Honorable Session Court Dibrugarh appeared and they were interrogated and allowed to go on bail after recording the statement. During investigation of the case, some documents related to the vehicle of the case being forced traveler bearing destination were seized and those were seen by the Honorable Court. Lord, the documents which are sought for from us, those were not seized, my lord. During investigation, the accused Kiran Gogoi, after obtaining interim bail or order from the Honorable Guwahati High Court, had appeared in the police station and he was interrogated and his statement was recorded, and having found his involvement in the case, he was arrested and allowed to go on bail bond. It is to be mentioned that during my investigation as the informant, Dawar Hussain Ahmed had handed over the original copy of the acknowledgement receipt of the handing over the vehicle to the branch officer so and so. It becomes evident that from handing over the vehicle to by the original owner to that office, Sri Ankur Chakraborty and Sri Kiran Gogoi in collaboration had criminally conspired and tried to cheat the informant to extort money. Moreover, the accused of Sri Kiran Gogoi done criminal breach of trust and fraudulently sold the vehicle to victim Devakanto Gogoi, and from which another Mohammad Asabuddin Ahmed became the victim. On this basis, under section 120B, 406, 423, 84, charge sheet was submitted. Now, I'll just take you to the seizure list, at page 227. This is the first seizure list, the originally is page 228. However, here this is from the informant, the petitioner in item number 2. One Xerox copy of the surrender slip of vehicle traveler, one Xerox copy of delivery receipt of traveler vehicle in the name of Dalwar so and so, one Xerox copy of RC, one Xerox copy of voter ID card in the name of Kiran Gogoi so and so. Now, Soumitra Boramir, page 229, my lord.
Okay.
He was a manager, Sumitra Borba. One surrender seizure report pad of Cholamani investment. So 5 numbers of surrender letters pad of Cholamani so. Now 231. This was seized from one Debakanto Gogoi. One original agreement for sale of a traveler so between Sri Kiran Gogoi and Debakanto Gogoi. Now 233. This is from one, huh? One Muhammad Asabuddin Ahmed Milot. The vehicle, serial number 1, the forced traveler bearing registration number damage condition was seized from him. One original so and so, one sale deed of traveler bearing number between Debakanto Gogoi so and Asabuddin Ahmed. Lordship has seen the sequence. The vehicle never came into our possession. He sold it to Milot number of persons. Ultimately, the vehicle was recovered from one Asabuddin Ahmed. The sequence of transactions below. Now, page 235 is yet another seizure Milot from Dalbar Hussain Ahmed. One original agreement, 7 copy of surrender slip of vehicle so and so. And thereafter, Milot, cognizance was taken, which your lordship will find at 244. Order dated 14/6/23. Case record is received for disposal, issue summons to the accused person, then prepare the copy. Now, on the face of it, Milord, it appears from the record itself, this vehicle was never handed over to us. It was a symbolic surrender. In fact, it was basically for the purpose of forcing Kiran Gogoi to deliver the vehicle. Even otherwise, Milord, by recovering the vehicle, what will the officer do? Milord, the question of cheating, 406, 420, Milord, can never be attracted. The mens rea, Milord, that will be totally absent, Milord. Yeah. But another thing, Milord, I'll just probably my learned friend is not aware of. This is an application on 2/9/2024 of the petitioner, Milord. This is, I could not bring it on record, Milord. Now he wants to settle the loan, Milord.
Gentleman wants to settle it.
Lordship?
Gentleman wants to settle it. Some people would have pleaded.
Naturally, Milord. Not deal. Now, so far, Milord, 130, now the first case is concerned, Milord. Lordship, I've seen the case is based on the surrender letter. Her claim is, Milord, that I had surrendered the vehicle, so there was no existing liability. In fact, from the record itself, it goes to show that the vehicle was never surrendered. So the Milord, liability will exist. Admitted position, Milord, they had issued checks, security checks, Milord. Security checks even otherwise. If there is an amount liable to be paid, Milord, if it is legally enforceable, it can be placed. This is the law. My learned friend has relied on a notice where the amount mentioned was in respect of the defaulted installments, not the entire amount. He has failed to pay the installments firstly. Future installments are there, and as such, Milord, there is a difference in the amount in the check as well as the notice, Milord. And in fact, my lord, in paragraph 15 of their petition, my lord, item 2, they say, my lord, that the petitioner begs to state, apart from the above, the respondent number 2 had also initiated an arbitration proceeding so and so before the sole arbitrator, where the petitioner has taken part and the same is still pending. This is a out and out of a false statement, my lord. He did not take part. In fact, an ex parte award was passed. You have not gone for execution, well, that is a different matter, but he did not appear. It is an ex parte award. my lord. Worship, I'll just rely on me, Lord. Ratish Babu's case, my lord. Ratish Babu Muni Krishnan was a state of. Whether the amount is due or not, these are matters which are to be decided in trial. Particularly, my lord, when there is a legal presumption that the check was issued towards a legally enforceable debt in terms of section 139. When the facts are disputed, my lord, they dispute. Let them prove. That is what the Supreme Court says, my lord.
Okay,
My lord,
you want to place some decision,
yes,
right?
my lord. Your lordship,
Which decision you are relying
last one, my lord, 2022, my lord, Supreme, SC 366, my lord. There is a case of Ratish Babu Unikrishnan versus the government of NCT of Delhi. So I'll just take you to paragraph 11. Lordship has got it, my lord. Supreme, report in Supreme today, my lord.
Amarjit Singh?
No, my lord, it's Ratish Babu Unikrishnan.
Yes.
I'll just take you to paragraph 11, my lord. The legal presumption of the check having been issued in the discharge of a liability must also be given due weightage. In a situation where the accused moves court for quashing even before the trial has commenced, the court should be careful enough not to prematurely extinguish the case by disregarding the legal presumption which supports the complaint. The opinion of Justice K.G. So-and-so for the three-bench judge of Rangappa versus Mohan so-and-so would be deserve our attention. We are in agreement with the respondent claimant that the presumption mandated by section 139 of the Act does not indeed include the existence of a legally enforceable debt or a liability, as noted in the citation. This, of course, is in nature of a rebuttable presumption and is open for to the accused to raise a defense wherein the existence of a legally enforceable debt or liability can be contested. However, there can be no doubt that there is an initial presumption which favors the complainant. At any rate, whenever facts are disputed, the truth should be allowed to emerge by weighing the evidence. On this aspect, we may benefit by referring to the ratio of so and so, wherein the honorable the following pertinent opinion was given by Justice R. Bhanumati. When disputed questions of facts are involved, which needs to be adjudicated after the parties adduce evidence, the complaint under Section 130 of the NI Act ought not to have been quashed by the High Court by taking recourse to Section 482 CRPC. Though the court has the power to quash the criminal complaint filed under Section 130 of the NI Act on the legal issues like limitation, criminal complaint filed under Section 138 of the NI Act against Yogesh Bhai was not to have been quashed merely on the ground there was an interstate dispute between the appellant number so and so without keeping the view of statutory presumption raised under Section 139 of the NI Act. The High Court, in our view, committed a serious error in quashing the criminal complaint in CC number so and so filed under Section 138 of the NI Act. Bearing in mind the principles of the exercise of jurisdiction in the proceeding for quashing, let us now turn to the materials in this case. On careful reading of the complaint and the orders passed by the message, which is discernible, is that the possible views that the checks were drawn here in discharge of a debt for purchase of shares. In any case, there is a legal presumption. It would not be judicious for the quashing court to carry out a detailed inquiry on the facts alleged without first permitting the trial court to evaluate the evidence of the parties. The quashing court should not take upon itself the burden of separating the wheat from the chaff and where facts are contested. To say it differently, the quashing proceeding must not become an expedition into the merits of a factual dispute so as to conclusively vindicate either the complainant or the defense. The parameters for invoking the inherent jurisdiction of the court to quash the criminal proceeding under Section 482 have been spelled out in Justice so-and-so for the two-bench in the state of Bhajan Lovely. I'll skip that part. Now I'll just fill out 16. Now, paragraph 16, my lord. The proposition of law as set out above makes it abundantly clear that the court should be slow to grant relief for quashing of complaint at a pre-trial stage, where the factual controversy is in the realm of possibility, particularly because of the legal presumption, as in this matter. What is also of note is that the factual defense, without having to adduce any evidence, need to be in impeccable quality so as to altogether disprove the allegations made in the complaint. The consequence of scuttling the criminal process at a pre-trial stage can be grave and irreparable. Quashing proceedings at preliminary stage will result in finality without the parties having had an opportunity to adduce evidence, and the consequence is that it is that the proper forum, that the trial court is ousted from weighing the material evidence. If this is allowed, the accused may be given an unmerited advantage in the criminal process. Also, because of the legal presumption, where the check and the signature are not disputed by the appellant, the balance of convenience at this stage is in favor of the complaint prosecution, as the accused will have due opportunity to adduce defense evidence during the trial to rebut the presumption. Situated thus, to non-suit the complainant at this stage of summoning order, when the factual controversy yet to be conversed and considered by the trial court, will not, in our opinion, be judicious. Based upon a prima facie impression, an element of criminality cannot entirely be ruled out here, subject to the determination by the trial court. Therefore, when the proceedings are at a nascent stage, scuttling of the criminal process is not merited. Here is a case, my lord. On the basis of the documents would show, my lord, the conduct of the petitioner itself. Now, lordship, the next case, my lord, S. Abdul, sorry, my lord, Yogesh Jain versus Sumesh Chanda. In fact, on the last occasion, we'll have.
Just a minute. Yes, next case you are relying on.
My lord, Yogesh Jain versus Sumesh Chanda, my lord. 2022 Supreme SC 1671. Paragraph 8, my lord. Once a check is issued and upon getting dishonored, a statutory notice is issued. It is for the accused to dislodge the legal presumption and available under section 118, 139, respect to the NI Act. Whereas the check in question, whether the check in question has been issued for a time-barred debt or not, itself prima facie is a matter of evidence and could not have been adjudicated in an application filed by the accused under section 482 CRPC. Now, next would be, my lord, HMT watches. 2015-11 SSC page 776, my lord. Just take you to paragraph, my lord, 8, 9, my lord, 138 is 139, section 140 referred in paragraph 9. Paragraph 10, my lord. Having heard the learned counsel for the parties, we are of the view that the accused respondent number 1 challenged the criminal proceedings of a criminal complaint case before the High Court, taking factual defenses. Whether the checks were given as security or not, or whether there was an outstanding liability or not, is a question of fact, which could have been determined only by the trial court after recording of evidence of the parties. In our opinion, the High Court should not have expressed its view on a disputed questions of fact in a petition under section 482 of the Code of Criminal Procedure to come to a conclusion that the offense is not made out. The High Court has erred in law in going into the factual aspects of the matter which were not admitted between the parties. The High Court further erred in observing that section 138B of the NI stood uncomplied, even though the respondent number 1 had admitted that he had replied the notice issued by the complainant also. Also, the facts as to whether the signatory of the demand was authorized by the complainant or not could not have been examined by the High Court in its jurisdiction under section 482 of the Code of Criminal Procedure, where such plea was controverted by the complainant before it. So this is yet another, my lord. Now, lordship, this is my lord, downloaded from live law, my lord. Criminal Appeal 516 of 2024, my lord. Atmajit Singh, it was given on the last occasion, my lord. Listen. Atmajit Singh, my lord. Atamjit Singh, my lord. Atamjit Singh. Criminal Appeal 516 of 2024. It is from the, not live law, it is probably Supreme today.
Yes, Atamjit Singh.
I'll just take you to Milo paragraph 7. This is a recent decision, Milo, January 22, 2024. For my perusal of the legal position initiated above, it is clear that the classification of the underlying debt or liability as being barred by limitation is a question that must be decided based on the evidence adduced by the parties. We agree with the said aforesaid opinion. Undoubtedly, the question regarding the time-barred nature of an underlying debt or liability in a proceeding under Section 130 of the NI Act is a mixed question of law and fact. It ought to be decided by the ought not to be decided by the High Court, exercising jurisdiction under 482 of the CRPC. In the case of Bir Singh, this is reported in 2019 for SCC Milo, 197. Here, Milo, the Supreme Court has gone to the extent of saying, Milo, if the check and the signatures admitted, that suffice. If the lordship kindly comes to page paragraph 32. The proposition of law which emerges from the judgments referred to above is that the onus to rebut the presumption under Section 139 that the check has been issued in discharge of a debt or liability is on the accused, and the fact that the check might be a post-dated check, post-dated, does not absolve the drawer of a check of the penal consequences of Section 130 of the Negotiable Instrument Act. A meaningful reading of the provisions of the Negotiable Instrument Act, including in particular Section 20, 87, and 139, make it amply clear that the person who signs a check and makes it over to the payee remains liable unless he adduces evidence to rebut the presumption that the check has been issued for payment of a debt or in discharge of a liability. It is immaterial that the check may have been filled in by any person other than the drawer if the check is duly signed by the drawer. If the check is otherwise valid, the penal provisions of Section 138 would be attractive. If a signed blank check is voluntarily presented to a payee towards some payment, the payee may fill up the amount and other particulars. This in itself would not invalidate the check. The owners would still be on the accused to prove that the check was not in discharge of a debt or liability by adducing evidence. Paragraph 35. It is not the case of the respondent case that he had signed the check. He either signed the check or parted with it under any threat or coercion. Nor is it the case of the respondent that the unfilled check, the signed check has been stolen. The existence of a fiduciary relationship between the payee and of a check and the drawer would not disentitle the payee to the benefit of the presumption under Section 139 of the Negotiation Instrument in the absence of evidence or evidence of exercise in undue influence or coercion. The second question is also so. Even a blank check leaf voluntarily signed and handed over by the accused, which is towards some payment, would attract presumption under Section 139 of the Negotiation Instrument Act in the absence of any cogent evidence to show that the check was not issued in discharge of a debt. In the other case, Milo, that is it was on the last occasion, Milo, I have given two judgments, Milo, from the live law that is already on record on the same lines, Milo. In fact, the other case is, Milo, there is a 2010-11 SCC, Milo, 441, which has already been referred in the other decisions, Milo. Rangaba versus Sri Mohan. So, Milo, on the face of it, the legal notice, Milo, implies that on that day, the amount was in respect of unpaid installments. The entire amount is due as on date. The due amount has been put in the check, Milo. So there is no illegality in so far, Milo. Let them come forward and say, Milo, that this was not issued towards any legally enforceable debt, Milo. And on the face of it, Milo, the vehicle was never handed over to us. It was basically to mount pressure. In the Vajanlala's case, Milo, this is basically to cause harassment, to force the Milo, officials of the Milo, finance company, Milo, to In fact, Milo, if your lordship, if once Milo, I can produce even a dealing. But dealing, but I give dealing. In fact, I have told Milo, there was an offer for, we offered 650 Milo. And the petitioner and Nightman 2 has agreed to pay that within 1 month. Milo, because the facts in itself is very evident, Milo. Check, the vehicle was never handed over to us, and his entire case is based on this surrender letter. He says the one the vehicle is surrendered, we do not have any liability. That is not the case. Insofar item 3 is concerned, Milo, the judgments we had referred to, Milo, this are already on record. On the very first occasion that I had placed.
May it please, your lordship. Lordship, I have no idea about any settlement, lordship. If they have the information about settlement, lordship, then why they argued the matter and wasted 2 hours of judicial time, lordship? They ought to have taken time, lordship, that the compromise is going on. And lordship, from the annexers which annexed in the criminal petition itself proved that, lordship, my affair is a true incident, lordship. All the originals, all the annexures they have enclosed with the criminal petition proves that after my surrender, lordship, they have again vehicle was handed over to some other person's, lordship. And my friend has said that the charge sheet your lordship will find, it is reflected from the charge sheet that the original surrender letter I have handed over to the investigating officer, lordship. Page 225, lordship. There is materials in the FIR which was instituted by the petitioner, lordship. So the accused persons have already taken bail, lordship. Charge sheet was charge was framed, lordship. Page 225, lordship.
Heard MSR Superior Land Counsel for the petitioner. In the criminal petition 385.
Lordship is disposing the matters, lordship.
You are appearing?
Regarding the second application, which is possible, for that I have objection. Because first question is that, my lord, after investigation, my lord, it has to be submitted, my lord. Now the trial court has issued summons to them, and they are setting the summons as well as the searches. Now notably, preparing of the searches, my lord, it shows that, my lord, the bank officers, my lord, they are equally involved, my lord. Because, my lord, there is a procedure. They can, my lord, approach the debt recovery tribunal. If the petitioner, if the, my lord, forward has not repaid the loan, my lord, and instead of, my lord, they have not followed the procedure, my lord, and they have sold the vehicle to other persons, and they have, my lord, indulged in, my lord, recovering the amount by depositing check, etc., and etc., my lord. So, my lord, my humble submission, my lord, in the trial court, my lord, at the stage of appearance, my lord, charges yet to come, my lord, they can take all the matters, my lord, at the time of pending of charge. So I oppose, my lord, the quasi judicial application.
Lordship, moreover, Lordship, I want to place on record this arbitration award, Lordship. As because this entire award amount is dependent on my FIR, Lordship. For a moment, if your Lordship is
And
5 minutes time,
Are
Lordship.
they learned counsel? Or the respondent number? In criminal petition 1345. Or Mr. Arde counsel appearing for petitioner. The learned additional purpose of the party. For the petitioners. One. Yeah, for the respondent number 1 and MS. You are appearing in the second matter, you are appearing.
Lordship, I have filed my wakalotnama.
Ram Arto, that counsel. During the deliberation of the matter. Mr. A. Learned counsel appearing for the respondent. Mandalam Investment and Finance Company. Placed a communication dated 02092024. Issued by the petitioner. Informing that we should be implementing the lowest amount to be payable by him towards the said finance company for full and final settlement of his Traveler 26 vehicle having registration number AS 23 BC 6871. For which he took loan by the agreement number X 15 FPTIP 0000186146 1468. indicating that he is ready to settle the said loan account so as to get the loan clearance certificate and other relevant documents by paying the reasonable amount. List on Friday. They said that MSR Sudhari Learned Counsel appearing for the petitioner as to whether he had approached the respondent number 2 finance company for settlement of the matter as per his said letter dated 0209. Yes, madam, you have been saying about the arbitration.
Yes, Lordship.
What do you have to say?
Lordship, in arbitration, there is a finding that this is maybe kept on record, Lordship. I have not challenged this award as because the entire award is dependent upon the outcome of the FIR, Lordship. Last paragraph 9, your Lordship, kindly say. And that arbitration proceeding was, Lordship, as my learned friend has pointed out, that we have not, Lordship, taken part, but in fact, the petitioner has taken part in the proceeding, Lordship. Paragraph 9, Lordship, the arbitrator fees is fixed at so-and-so. In the result, the award is passed in favor of the claimant herein as follows. The respondents are hereby directed to jointly and severally pay to the claimant the following amount. The claim sum of rupees 6,07,429 as on 19/9/2019. Further interest at the rate of 18% per annum of rupees so-and-so until the date of actual payment. In case of respondents failing to make the above payment, the respondents are directed to surrender the aforesaid vehicle and all relevant documents to the claimant. In case the respondents failing to surrender the aforesaid vehicle, the claimant is at liberty to repossess the subject vehicle lying at the premise of the respondents or wherever found, either by unlocking or towing or break open of premises if necessary, with police assistance, sell it and appropriate the sale proceeds towards the award amount and proceed against the respondent to recover the remaining amount, if any.
It's okay, it's okay.
Now, Lordship, execution of clause A and D are subject to the outcome of the final order to be passed in case of 7/8/2019 pending before the Honorable PS Dibrugarh. So the third petition, Lordship, which they prayed for quashing, it may not be allowed only because of this clause, Lordship. Additionally, Lordship.
Ms. R. Chaudhary and Counsel. The other end for execution of subject. That in a arbitration proceeding, with regard to the default of amount of payment of default payment, default in payment of the monthly installment for the said vehicle Friday number 2. The concerned arbitrator on 24/03/2023 passed an award for an amount of rupees 6,07,429 as on 19/10/2019 with interest at the rate of 18% per annum. The said amount of 0.06/07,429 from 2010/2009 until the date of actual payment. Where the execution of the said award of the arbitrator is again subject to the outcome of the final order to be passed in case number
Dibrugarh PS case number 788 of 2019.
Dibrugarh Police Station case number 788 public report on the corresponding to PRC number
PRC number
685/2023. Reference GR case number.
PRC case, it will be PRC, my lord, as of now.
Initially it was GR
Initially. it was nominally-
1840 of 2019, page 2, Lordship.
1840. Released on Friday or Monday?
Monday, Lordship.
Night.
Highly obliged.
My lord. Lord, your lordship asked me to submit a list of when, how much was given. There is just one confusion, my lord. So the interim payment was supposed to be made from the date of the application. So I have been told that the date of application is 4/2/21, but I could not check the record, my lord. It was already with your lordship. So if I can get some time to check the record, the date of application.
My lord, may I submit, in any case, my lord, for interim maintenance also, my lord, the procedure has to be followed.
Just a minute. Mr. Busso, where is the hunt? He's not able to tell you. We have fixed those matters where the Rajneesh and Sneha matters have not been followed. They're clubbing together because in most of the cases you have been seen that even after personal test. So she was in those matters. She'll be able to say in which state it has been fixed. May it come in he may know. Mr. Raman, in most of the cases, what we have seen,
My lord.
with regard to the expense of maintenance, either in the 125 proceeding or in the DV case or before the requirement is that the judgment of
My lord.
Rajneesh and Sneha has to be followed. But here even in this case, what we have noticed has not been followed. These matters are on fifth,
On
coming
fifth,
Thursday.
my lord, may
Let it
fix
be
it
on
on fifth.
Thursday. Let it be on Thursday.
My lord, my lord.
Okay, along with the number to be.
Deep, all right.
Yeah, Lordship. Lordship, the LCRs have been received, I think.
Here is the office note. Dated 22/8/2024. It is submitted that Mr. Das is not well. Mr. S. just planning to for the petitioner is in this post. Placed on fifteenth.
Deeply obliged, Lordship. May it please your Lordship?
So, Bush, some report was sought for from Manipur police station. It's a matter relating to containing of NDPS materials in a e-rickshaw.
My lord. My lord, maybe give me some more time, my lord. I'll obtain.
Earlier also you have granted you time.
Lordship, the e-rickshaw was seized in the year 2023. 1 year has already left, Lordship.
This was, in fact, we directly concern OC to be here, IO to be here, personally present. We don't know what you have done. The order of the copy was also, copy of the order was also duly served. On the request of Mr. K. Boysel, an additional public prosecutor. Matter is adjourned today and fixed on 13th of September, failing the said that failure on the part of the IO to furnish the relevant report that was sought for by order dated 14/08/2014, 27/03/2014, 27/03/2024, and 14/08/2024. The investigating officer of Manipur PS case number 108/2023 shall personally remain present. Mr. Bush, sir, no second sentence.
My lord.
Much obliged, Lordship.
Deeply.
May I please, your lordship? Lordship, here, the report with regard to the freezed account of the petitioner was called for. Report 18 report on
Yes, Mr. Boyce.
My lord, in this matter also, report not received, my lord. I look very.
List on 16th. On the said date, the investigating officer of Jalukbari Police Station, case number 25/2024, shall apprise the court about the updated status of the said police case. And further, with regard to the amount freezed in the SBI account number 409885093345, with the State Bank of India, Guwahati Airport Terminus, Roger, VIP, Guwahati Airport. Seized and freezed in connection with said Jalukbari case number 25. Failing which, court shall consider to pass consequential order considering the fact that the court on 19/08/2024 itself called for such a court, fixing the matter. Copy of this order.
Deeply obliged.
May I know? Actually, in this case, today's date to go through the record by additional PP Jahan. Okay. Hello. Record cover. Record cover. Time. Night.
Take your seat. You will come back at 2. You are appearing for whom?
My lord, I have preliminary objection, my lord, because, my lord, they have come with this criminal petition with two, my lord, ground. One is that, my lord, to quash the entire proceeding. Secondly, the search sheet, my lord. But they have not challenged the magistrate order. By which order, my lord, the cognizance was taken, my lord. It should have been pointed to the magistrate, my lord. Because, my lord, if lordship, my lord, quash the, assuming, my lord, lordship has quashed the proceeding, my lord. Then, my lord, entire, my lord, search sheet will go, my lord. Wherein, my lord, the accused number 2 has not been, my lord, cited as an accused, my lord, in the search sheet.
Only with regard to petition number 2.
2, my lord. That had already, my lord, she has been discharged, not discharged, my lord, not charged, my lord. She has been exonerated from all the charges, my lord, as per the search sheet, my lord.
You know why the magistrate have passed that order?
That may be, my lord, there may be some mistake, my lord, that is why, my lord. But they have not challenged that order, my lord. The magistrate has taken cognizance in spite of, my lord.
That is
filing
not the
the-
challenge.
Yes.
That is not it. With
That is why I am
regard to the-
submitting, my lord, this petition is not maintainable, my lord.
With regard to the petition number 1, let it be decided in the.
Lordship, from the FIR and the charge sheet, Lordship, there is no English of 376, Lordship.
We have gone through the records.
And Lordship, even after Lordship charge sheet, Lordship, this honorable court, Lordship, was the Lordship proceeding, Lordship.
No, even after search sheet, it can be quashed.
Lordship.
Only when the materials are different, right?
Yes, Lordship.
But here something else is there.
Lordship, there is no ingredient.
The statement of the victim, other independent witnesses as it reveals. So, will not interpret.
Lordship, even Lordship, with there is no ingredients of 376, Lordship.
That will be during the trial at the time of framing of charge. It will be taken care of by the court. Right? The magistrate cannot take. And not to frame charge 376 is.
Lordship, if it is,
in the
Lordship,
committee
no
in court.
ingredients, Lordship, then the continuation proceedings may be abuse the process of law.
That is your submission, but the record reveals something else. But with regard to petition number 2, we'll clarify.
That may be, my lord, some mistake, my lord, while taking cognizance, her name has been mentioned. my lord.
That will take care of.
Yes, my lord.
Partly allowed. But Mr. AMS Magundar, counsel for the petitioner. Mr. Deka, right?
My lord.
You are Mr. Deka.
RJ Burwa, my lord.
RJ Burwa.
My lord.
That MSKLR Youngton, right? Your name?
Correspondent number 2 also.
Na naam to panna.
Wrong, my lord.
Wrong, sorry. Wrong. This is the. What is your submission?
Lordship, after the investigation and taking of the statement of the witness, Lordship, my humble prayer, or Lordship, let them face the trial, Lordship.
Lordship, I may supply to the judgment.
You will take care of that.
I plead the lordship. Lordship, up to date status and report pertaining to investigation,
You got it, Mr.
PM
Lord?
report.
No,
Plus
that
was
we have
called for.
we have not received, my lord.
Lordship, I have certified copy of PM report. In the last occasion, I have submitted AB number 2214, which was rejected by this court. Then 40 days in custody. 304B.
List on 16th for the up-to-date report pertaining to Gosaigaon PS case number 33/2020 that was called for by order the 22/08/2024. Failing which the concerned investigating officer of Gosaigaon PS personally remain present for the
My lord, my lord, the short written arguments I have prepared, my lord. one page for a convenience.
My lord, in this case, my lord, scan copy was called for, my lord. I have perused the scan copy, my lord. Out of, my lord, 11 witnesses, my lord, 4 witnesses have been examined, my lord. And all the witnesses, lordship, they are Caesar witnesses and they have gone hostile, my lord. Now, my lord, out of the 11 witnesses, 4 witnesses are examined, 7 witnesses are yet to be examined, my lord. And then, my lord, the contraband, my lord, it's related to commercial quantity, my lord. So rigors of 37 will come, my lord. So at this stage, my lord, I oppose this bail application, my lord. Because the certificate case trial is going on, my lord. Last witness examined on 6/6/2024, my lord.
Record reveals something else, Mr. Chaudhary. On 2 occasions when the witness was present, defense took time.
Yes, my lord.
In April, in March,
Sometimes, my lord, there was a bona fide reason sometimes.
so you cannot say straight away that only because
Submission, my lord, that 2 years, 5 months. So, my lord, any condition I will appear, my lord, will not leave from their district, my lord. Young age, my lord, very young age. Well, almost 2.5 years have gone in jail, my lord. Will appear in every date, my lord, with any condition. My lord.
then you look into it.
My lord, I would like to place some judgment, my lord. if you
Leave it
allow.
as look into it.
Long days, my lord, very young in age, my lord. Any condition, my lord, I will appear every date. Will leave the district, my lord, not leave the district.
Okay.
Obliged.
Report was called for, my lord, on behalf of the
My lord, in this matter, the report was called for. My lord, one report we received, but my lord, that was an earlier report, my lord. I have just gone through it. And it is 12th of July 2024, my lord.
প্রশ্নটা আমি এখানে চেক করবো।
Civil Johan. Civil of potato.
এটা তোমার প্রধানত বিষয়টা একটু হলো তোমার অফিসার হিসেবে যদি অ্যাডভান্স করতে হবে, তারপর তখন প্রিমিয়াম থেকে রেজিস্ট্রেশনের পরিমাণটা করতে হবে। বিলিং বলতেই তো
From your office, it hasn't gone.
My lord,
From your office, it hasn't gone to the police station.
my lord, it is letter is 12th of July, my lord. Reply. But that's because jail appeal it may be directly by the registry, my lord.
Eleven 2020, my lord, notice was issued to OC. Thereafter, reminder has also been sent by the registry on, as per office note dated 22/4/2021.
We'll appoint a matter school.
My lord,
That will be better.
my lord.
These people are not working. You also cannot afford to have the report properly. Bornita Chaudhary, BARNITA. Amicus Curie. As per the notification number 23, dated 18/04/2024 of the registry of this High Court, be appointed as a legal aid counsel for the informant. That's one number 2 of the case. The registry shall provide all the relevant documents to such and such, obtaining necessary acknowledgement. The registry shall also reflect the name of such and such in the cause list against the title for the informant as per number 2. List on 10th.
Okay.
Hearing of kind.
Okay, in this case, Lordship, LCR arrived, Lordship, and service also complete, Lordship. The matter may be fixed for hearing, Lordship. As per the last order,
registry have given me the papers. I've been appointed amicus, registry has furnished me the papers.
You have gone through the paper.
I can fix for hearing.
Children, counsel appearing for the appellant. Additional public prosecutor for the state respondent number 1. Also heard Mr. D.K. Bhachaji, right? Learned amicus curie for the respondent number 2. By order dated 21/07/2023, this appeal was already admitted. This appeal, this statutory appeal is against the judgment and order dated 16/06/2023, passed by London Additional Session Judge from Special Judge POC Sutin Chukia in POCSO case number 172/2022, convicting the appellant under section 376 within bracket 1 of the period of detention already undergone by the appellant during investigation and oblique trial of the case. It is seen from the this appeal was admitted pursuant to the order reported 21/07/2023. Registry has already received the relevant records. It is seen that during investigation of the case, the appellant was in custody for the period from 08/09/2022 to 28/10/2022, and thereafter, since the impugned judgment of conviction and sentence dated 16/06/2023, serving the sentence. Place this appeal for hearing in its usual court.
Yes, yes.
May I plead your lordship? Lordship will kindly peruse order dated 19/8/24, your lordship. I am appearing for respondent number 2, your lordship, all along in this case, but on that date, your lordship, I am extremely sorry, I couldn't.
Doesn't matter. Mr. Foucault will set you free. Yes.
Your lordship, I have the orders of my appearance.
Heard Mr. Ayub Chaudhary, counsel appearing for the appellant, and Mr. K. Boisseau, London Additional Public Prosecutor for the respondent state. MS F. Hussain, London Counsel, appears for the respondent number 2. On last occasion, I on 19/8/2024, the Ms. Hussain did not appear in the matter for which Mr. Aruna Fukan and listed MI Security was appointed as the legal counsel for the respondent number 2. Since Ms. Hussain has entered appearance today, suitably for the respondent number 2, engaged by the state respondent. Mr. Fukan, my security has been relieved. That is special. Really his name from the court list and against his disciple and from the court. Yes, Ms. Fukan. You can hand it over to Mr. Boisseau. By judgment and order dated 21/08/2023, London Additional Session Judge number 2, Nagaon, in sessions within bracket T1, bracket close, case number 41/2015. Impugned judgment. Convicted the present appellant under section 304B of the IPC and sentence him to undergo rigorous imprisonment for 10 years with fine of rupees 10,000 in default of payment of fine to suffer simple imprisonment for 6 months. Hence, this statutory appeal by the appellant. Pursuant to the order of the court, 26/09/2023, registry has already received the relevant records. By order dated 26/09, it is appeal was admitted. The records from the trial court was called. Registry has already received the relevant records. Matter be admitted for hearing. Place this matter for hearing in usual court.
Deeply oblige, Your Lordship.
May I please, Your Lordship, Lordship, this is criminal appeal matter, Lordship, arising out of the judgment and order dated 29/6/24 by the additional session judge Tipsagar, also in special POCSO case number 64 of 2023.
Mr. Fukan was here. Mr. Fukan, don't go away.
Lordship,
You have another responsibility now. There is the office note dated 29/08/2024.
Lordship,
Or
LCR is not received, Lordship. Mhm.
Mr. Fukan, not at this stage. Records have not yet come. We will inform you, but get ready for this item. On the next day, we will see.
Thank you.
Lordship,
Office note dated 12/8/2024 and 29/08/2024. 29/08 Anthony Lekua, Itia Anthony Lekua, 31/08/2020. This will reminder to the Court of Learned, to the Learned Additional Session Judge, from Special Judge POCSO Sipsagar, for the records of special within bracket POCSO case number 64 of 2023, decided on 29/06/2024. List on 24th of September.
Yes, Lordship.
Yes, Mr. Busso, we have called for the records of Pragjyotispur Police case number 24 of 24. You don't have the report.
My lord, report not received, my lord.
By order the 27/08/2024, the up-to-date scanned legible copy of the case diary relating to Pragjyotispur PS case number 24 of 2024, corresponding to GR number 665 of 2024 was called for.
My lord.
Fixing the matter today. Mr. Bushel, an additional public prosecutor, however, submitted that he has not been furnished with the said record. List on 1909. Failure on the part of the concerned investigating officer of Pragjyotis PS case number 24 of 24 to place the up-to-date scanned copy of the said case diary. He shall have to personally remain present because it will be 10:30 AM. On the said data on such and such. As this order has been passed in presence of Mr. K. Boysa, additional public prosecutor, Assam, no formal notice need to be issued to the investigating officer of said Pragjyotispur PS case number. The copy of this order be furnished for it.
Effective
কোনো এখন objection দিবলৈ পাৰো। আৰু এই মেৰিটত খেলটো টেষ্ট কৰিব লাগে। মই কৈছোঁ তাক মই কথা কৰি মেইন টেষ্ট ইয়াৰে নাথাকে এটা কথা।
Mr. Busso, what is the issue about? This is a very important issue. 5 acres of land was an owner who expired in 1973, August.
Right.
And then impersonating someone, impersonating that person, the owner of the land. The sale deed was executed sometimes in 2009. Then there was a mutation case, their names incorporated. But the real owner of the land expired in 1973.
My lord.
And why the case there has not been proceeded?
I don't know the next.
Mr. Busso, something is,
My lord.
as you know, every day is not Sunday.
Right.
Sometimes you will be in trouble. If you do not have any power over the police stations regarding the records when the courts are asking for. This morning, we have not received any case records from you. Not a single case there has come. Why? Why? Tell us, why? Not a single report. You have seen, you have been there in the morning, since morning, right?
Yes, my lord.
Why it is not? We don't know.
I'll inquire the
You have to
matter.
face the plant, I'm telling you. And in this kind of cases,
My lord. I will inform the matter to PP also. My
and see why it is not been forwarded. The reason is simple. It's a land grabbing matter.
yes, my
Person expired in 1973. There's a report,
then there.
and that's why the case record is not coming. That reflects Indian globes with somebody. SP might have to be here. We don't know. Next time anything, we are giving the dates. It's not there. I'm telling you, Mr. Busso, the SP may have to be here. We don't know what order will be there.
I will inquire the matter, my lord. Inform the PP also.
Yes.
Lordship, kindly today observe this matter.
Not prepared.
My question, last date I was sick, I couldn't attend. So
Out of
it's getting remarks from me. My lord, this is they are pressing a 389 application. Conviction is under POXO and 366. 10 years punishment. Perhaps PP will also like to file.
PPA is not filing any objection.
Copy na
4 sanctions has been granted to them. Up to them. If there is no objection, we will pass on the matter. You have given them time.
My lord.
You don't know, Mr. When do you want?
1 week.
On the prayer of the council for the applicant matter be adjourned for 2 weeks. My lord. We still is the matter on the date to be fixed by it. Yes, Mr. Ali. What's the matter about Mr. Ali?
My lord, appeal has already been admitted, my lord, and your lordship fixed today for consideration of the suspension of sentence.
Okay.
And on the last occasion, my lord, your lordship directed them, learned pen to file objection. They have not filed objection earlier also, my lord, they took several
Well,
times.
take up the matter. Doesn't matter. State is
Lord.
not filing. Why do you bother? If you want to, if you are interested, they will take up. Otherwise,
Lord.
we'll adjourn. Up to you. Up to
My
you.
lord, here the conviction, my lord, under section 304 B, my lord. And the learned trial court, my lord, convicted the husband along with father and mother of the husband. And we have annexed the, my lord, LCR has also received, my lord. We have annexed the FIR, my lord, in our additional affidavit. Marriage took place, my lord, 3/5/2010. And date of occurrence, my lord, 6/12/2014, within 7 years. And by taking the presumption, my lord, the conviction has been, my lord, awarded. If your lordship consider the FIR, from the FIR itself, my lord, there is no, my lord, allegation of demand of dowry. Except the date, my lord, within 7 years, my lord, no ingredients is available. And
Mr. Ali, take your seat. Mr. Busa, take your seat.
Okay.
Yes, Mr. Busho, what do you have to say? Have you gone through the record
My lord, I need some time, my lord.
day after tomorrow?
My,
Go through the records.
my lord.
Okay, yeah. Okay. We'll have it day after tomorrow. Let Mr. Busho go to the record.
Yes, all right.
Order related, I don't know.
For hearing item number 26.
This is your petition.
Lordship, may kindly accommodate the matter for time being, sir, senior is in another court. One matter is.
Do one thing. Read the judgment. Read the judgment. Till Mr. Kolita come to read the.
Your Honor, this is not relating to any judgment.
Yes.
This is not relating to any judgment.
No, this is the petition,
Ah.
right? That means case number. Want to pause this, right?
Yeah, they are going for the partial mayor, praying for the partial.
Order dated 10/9/2018, page number 28, annexure A2. May I read it out? Petitioner is present. This case has been filed by the petitioner, Srimati Sharma, under section 125 CRPC, claiming maintenance for herself from the opposite party husband, Ashok Purohit. Notice was issued to the opposite party, but the opposite party failed to appear before the court and has to submit his written statement. Hence, the case is proceeded ex parte against the opposite party. The case of the petitioner, in brief, is that she is legally wedded wife of the opposite party and their marriage was solemnized on 21st February 1996 as per Hindu rites and customs. That at the request and proposal made by the opposite party and his family members, the marriage between the parties was held at Udaipur, and soon after marriage, they started their conjugal life at Patna and stayed till August 1998. As the opposite party used to do service at Hindustan Times at Patna, that the petitioner moved to her parental house at Guwahati, Assam for her delivery on 10th January 1997. Their only daughter was born, and after 3 months, she again moved to Patna. That from the outset of their conjugal life, the petitioner became the victim of mental and physical harassment and torture caused by the opposite party. That the opposite party never left a single chance to underestimate and torture the petitioner. That the opposite party often demoralized the petitioner on very negligible plea and commanded her to follow whatever the opposite party would like and wish to do. That in the year 1998, the opposite party got job in Muscat. That the opposite party advised the opposite party not to take that the petitioner advised the opposite party not to take the job. But the opposite party was not a person to respect and respond her opinion and left for Muscat, leaving her and their 1.5 years old daughter alone at Guwahati. That as the opposite party was least bothered and irresponsible towards the petitioner and their minor daughter, she contacted the sister of the opposite party, and she advised her to move to Udaipur. And accordingly, she moved and stayed for 6 months with her in-laws. And in the 2000, they moved to Muscat. That a few days after marriage, one of her cousins visited petitioner's house, and by the time of the opposite party returned from his work and asked for a glass of water, but as she served the water, the opposite party flung the glass of water on her and flung the glass on the tray unprovoked. Unprovoked. That for each and every minute mistake or even not having any mistake, the petitioner had to face utmost cruelty caused by the opposite party. She was not given sufficient food to. Even during her first pregnancy, the petitioner was compelled to adjust with hunger. That for a minor argument, the opposite party strangulated her, causing her difficult to breathe. But somehow she escaped. That the opposite party often mentally humiliated her in extreme manner and used to push her out of home for not mopping the house to his satisfaction and forced her to go to work even though she was not interested to do so. That the opposite party demoralized the petitioner and passed vulgar and cheap comments on women and used to speak about his immoral sexual relation with other women. That the opposite party used to step and crush her feet and hands while she was sleeping. That the opposite party used to forbid the petitioner to sleep at night until he went to sleep, even after completing entire household chores, and then often used to kick and push her to switch off the light at late night, even if she was tired. That the opposite party used to have conjugal relation forcefully with the petitioner during her menstruation period. That the elder sister of the petitioner moved to Udaipur for 5-6 days to stay with her. The second day, while her sister was taking bath, the opposite party peeped her sister through a ventilation of bathroom, and immediately her sister
And a quote, while issuing notice by ordered the 2101 order to notice in this revision by ordered the 2101-2011 connected criminal miscase number 62 of 2011 suspended the judgment and order the 07/12/2010 passed by the learned session judge Dhubri in state criminal appeal number 15 for 2019. Affirming the judgment and order passed by the learned session judge Dhubri in GRD case number 123 of 2022 and allowed the petitioners to remain on previous bail granted by the learned trial court. On the next date, Mr. Kayum Nilekyo. On the next date, Mr. Kayum as well as Mr. Borua shall make their appropriate submission on basis of the records of the trial court as well as the